Well, the long, and I mean long, legal fight over a water dispute between New Mexico, Colorado, Texas is going to continue. The Supreme Court has rejected a proposal between the states, saying that the federal government has not agreed to this plan. Roger McEowen with the Washburn School of Law joins us now for more information on this. So obviously, water, a big issue in the West for agriculture because of its scarcity, right? In this case, the states came up with a plan. Sounds like it just wasn't up to them. There is a lot more to this than just Texas and New Mexico. So tell us about this.
Well, good to be with you, Suzanne. Yeah, there's that little thing known as the Constitution that kind of gets in the way sometimes. And a little bit of background on this. Colorado, New Mexico, and Texas signed what's known as the Rio Grande Compact back in 1938, and Congress approved it in 1939. And that is an agreement that fairly apportions the waters of the Rio Grande Basin. And under that compact, Colorado committed to deliver a certain amount of water to New Mexico at the state line. And there was also a minimum quality standard that was established. Well, fast forward to 2014, Texas sued New Mexico for allowing the Rio Grande's water reserves to be channeled away for its use, which deprived Texas of its equal share in the river's resources. And a lot of that was caused by the increased prevalence of groundwater pumping for agriculture in New Mexico.
So we're going to talk about the Supreme Court's ruling here because there is so much more, again, just in Texas and New Mexico divvying up what they want.
Well, when that lawsuit was filed in 2014, the federal government intervened and said, look, we need to be a party to this because we're operating under a 1906 treaty with the country of Mexico to deliver a certain amount of water to them out of the Rio Grande. And you can't just enter into agreements by yourselves and cut us out when there's a federal interest that's involved. So the federal government sought to intervene, and the Supreme Court in 2018 said that's right. The federal government should be a party to the case because of that 1906 treaty, and because the water is actually delivered by a federal Bureau of Reclamation project administered by the Department of the Interior, which in turn has obligations to the Indian tribes, which also have an interest in the water. So you got all of these different parties that have interests in this water. And so after that, Texas and New Mexico came up with their own deal. They entered into a proposed consent decree, and the federal government objected to it, saying that's inconsistent with the original compact back in 1936 and undermined the compact's plain language, which they said the states can't do without Congress approving it. And that's what the Supreme Court agreed on just a few days ago. They said this has to go through Congress when the federal government has interests that are involved.
So, Roger, what happens next then with this case? Are they everybody having to just stay put and wait till the federal government decides what's going to happen?
Now, these water cases are incredibly complex. And so what the Supreme Court did was send it to somebody called a special master, which is a judge that has special capabilities with respect to water law. And this is all on the basis of Article 1, Section 10, Clause 3 of the Constitution, which says that the states can enter into compacts, but they have to get congressional approval. They can't do this without the consent of Congress. And that's been interpreted, not on every time that the states enter into water deals. They can do it without congressional approval, but when there are federal interests involved, they have to get the Congress involved. So this special master is supposed to figure all this out, and then it'll be subject to congressional approval. So it's going to slow things down, that's for sure.
What kind of precedents does this set? Do you see the federal government, of course, overseeing other issues when it comes to water issues?
Well, that's a good question. Primarily out in the West, I think that's where we will see the impact of this, because in the West, of course, the federal government owns a lot of the property in the West, and you have Bureau of Reclamation projects. And so you have the Department of Interior that's involved. And this would seem to indicate that more often than not now, the federal government needs to be a party to these compacts under the Constitution, as the Supreme Court has recently construed that. Now, points further east, I don't see it changing much at all because you don't have those federal interests that you would have in the western states.
All right. Great stuff, as always. Thank you so much for breaking this all down for us. I'm sure this is a case that we're going to continue to follow. And by the way, happy first birthday to, of course, your grandson. Beautiful little boy. I know you're excited to celebrate with him. Roger McEowen with the Washburn School of Law. Thank you, Roger.